Welcome to the Global Investor Podcast, a show that focuses on helping foreign investors enter the lucrative U.S. real estate market. Host Charles Carillo combines decades of real estate investing experience with a professional background in international banking to interview experts in all areas of U.S. real estate investing. Now, here's your host, Charles Carillo.
Hi, global investors. Before we get started with today's episode, are you looking to finance your U.S. real estate investment as a foreign investor? Contact universalcommercialcapital.com. They do not require any credit history, employment, income verification, or permanent residency status. All you need to have is the minimum 35% down payment in a U.S. banking institution for 2 months. Rates start at 6% with a 30-year term. The whole approval process can be completed in 30 days. Call 888-334-9039 or email them at info@universalcommercialcapital.com. Welcome to another episode of the Global Investors Podcast. I'm your host, Charles Carillo. Today we have Mauricio Rauld. Mauricio is the founder of Premier Law Group, a securities law firm based in Southern California, and focuses on assisting real estate investors with staying compliant when raising money from passive investors. So thanks so much for being on the show today.
Oh, thanks for having me. Really appreciate it.
Yeah, that's great. So are you able to give a little background professionally on yourself before you started your current law firm?
Oh man, I hate talking about myself too much, but yeah, so I started my law firm in about 2006. So before that, I did what every lawyer or law student dreams of doing. Really, I went and worked for a large law firm, really one of the largest law firm in Long Beach, California, where I did securities work and I did litigation. So I represented sort of the JP Morgans and the Prudentials and the Goldman Sachs and the Merrill Lynches of the world. But it was all litigation. So it was always, something already happened. There was a lawsuit. I would be the one who got the complaint. And then it was my job to go through that litigation process, put a response together, do the discovery, the depositions, the motions, the trial work, the appellate work, that whole thing, which is great. That's where I cut my teeth. But I did that for about 7 years. Just really knew that's not what I wanted to do. I've shared my story many times that I just kind of, luckily for me, realized, I think it was after reading that Rich Dad, Poor Dad, great book by Robert Kiyosaki. I just knew that's not what I wanted to do for the rest of my life. And so thanks to Robert's book, I connected with the real estate guys and then made the decision to leave the law firm and go work in-house for the real estate guys. And that's kind of where I really cut my teeth on the syndication piece, still securities, but now instead of doing, the litigation part, which is when everything's already gone south, it's on the front end, making sure that we're doing the securities work properly, which is a lot more fun actually, because now everybody's interests are aligned. There's no battle between the lawyers. It's the client. Everybody actually likes to work with me now because they need me in our firm to get to their goal of raising capital and closing on a particular property. So it's been a nice transition that happened back in 2006.
Yeah, I saw Robert Helm speak live a few months back. He's great. He's a great real estate investor. Brings a lot of different experience to the table.
Yeah.
With real estate investing being so unpopular these days, especially like syndication, there's a ton of inaccurate information I see online and mostly on social media. Are you able to give an overview of what the typical, Regulation D is normally in the 506C, 506B, which is most likely what real estate people are going to be using when bundling money, let's say, for purchasing a property. Can you give a little background on that regulation?
Yeah, so just a quick step back. Anytime people are raising money and selling securities, we either have to register that security with the SEC or we need to find one of these exemptions, right? Or otherwise it's illegal. It's kind of my third joke. But we never register things, so we always look for exemptions. And by far the most popular one is the one that you referenced, Rule 506B as in boy. And the reason that's so popular is because a couple things. Number one, it provides us with certainty. It's a safe harbor, which means if we comply with all the terms, then we're kind of assured of being in compliance. And certainty is obviously a nice thing for us. We don't want to be doing things and having to argue in front of judges or regulators to try and figure out if we did it right. Like we want to know that we did it right. And the other reason is it's a federal statute, and so we don't have to worry about the state rules and regulations. So we don't have to go hire an attorney in every single state that we're talking to investors or getting money from investors, which would become really expensive and cumbersome and time-consuming and honestly a nightmare if you had to go compare and contrast, 8 different statutes from 8 different states. So that's why it's so popular. And just as a really quick high-end summary, with a 506B, you're allowed to raise an unlimited amount of money, which is why some of those prior clients I had, the JP Morgans and the Merrill Lynches, they use 506B to raise billions of dollars. I mean, I used to reference there was a JP Morgan real estate fund that was 1.2 billion, but I just saw, and I posted it about a month ago, a Blackstone fund that was $20 billion. And, if you look at the filing, it's a 506B. Just like the ones that you and I do.
Wow.
So it's an unlimited raise, which allows you, obviously gives you a lot of flexibility. And it allows you actually to accept, for us smaller folks that are not JP Morgan, it allows us to accept a limited number of non-accredited investors, which is one of the most attractive things for us, meaning we can take friends and family who may not be a high net worth individual, accredited investor, you've got to have $1 million in net worth, excluding your personal residence, or have earned $200,000 the last couple of years with a reasonable expectation of earning it this year. So with a 506B, you can take investors who don't have that high net worth up to a certain amount. You're limited to 35, but that typically doesn't come into play. But the big whammy or the big negative of 506B is really you just cannot advertise. So you cannot go to the marketplace on podcast or running ads in whatever media, traditional, social, about your deal or podcasting. You just can't do that. And so you really have to stick with friends and family and people you have what's called a pre-existing substantive relationship, because it is meant to be a private offering and not out for the public. So those are kind of the big three things from a 506B. There's a couple other small ones, but that's kind of the big ones.
So advertising isn't legal for if I have a 506B and I have a deal already under contract, and that's what I'm planning on doing. So I can't obviously bring that to investors that I don't have a prior relationship with. How are syndicators able to promote their businesses without promoting the offering? Yeah,
that's a fine line. So, and I've spent a lot of time the last couple of months on social media talking about this. You cannot obviously talk about the offering. We just went through those rules. Yeah. So you can't talk about your deal, but you've got a business to run, right? So, you can certainly, the SEC has recognized that you can go ahead and talk about your business. You can talk about what your business does, what you do, what your credentials are, and continue to market your services like you do anything else. You can also clearly do value adds, which is why podcasts generally are really a cool tool if done properly, because a good podcast is exclusively a value add. You're just providing great information with great guests and great information. So that's another thing you can definitely do. But the tricky part is people have this tendency to not stay the course, and so they talk about their business, or they talk about themselves, or they do a nice value add piece. But inevitably, what happens is they cross that line and they throw in the, hey, look, if you want to learn how to make a lot of money, if you want 20% returns, give us a call. And that's where things kind of cross the line. It's really, just making sure that you stick to that. I think it's very difficult to do, which is why my position has been, if you have an active deal, I mean, two things. One is, if you have an active deal, I recommend people just stay off of social media relating to real estate or the business. Post about your kids, post about everything else, fine, but just don't even play that game. And then when you don't have an offering going, then value add and talk about your business. But the other thing that I've started to talk about quite a bit, and you'll probably see a little bit more of it coming up here shortly, is if you're going to play that game, which is a fine line, where you're just talking about your business and what you do, or again, my favorite is the value add. So putting out articles about, why real estate is such a great investment vehicle, or why, the state of Texas or the, Plano, Texas is such a great market. You can do those value add pieces. But if you're going to do that, you want to make sure that you are steady, like you are just consistent with those posts. Meaning, if you're going to post once a day or once a week or whatever your consistency is, just post once a week or once a month. What you don't want to do, which I see a lot of, is somebody doesn't post anything. They're never on social media. They're never on podcasts. They never do anything about their business. They never give any value add. They never do anything about their business. But lo and behold, 2 weeks before an offering, you suddenly see an uptick in the activity of these people, talking about themselves and talking about social media, because what they're talking about value add, because they really are trying to get people interested in their deal. And then, as soon as the deal's done, they go back to doing absolutely nothing. So you have this bell curve that exists where nothing gets posted, or no advertised, or no posts at all. And then there's kind of a bell curve. And then as soon as the deal's over, it goes down. That's not a good look, because it's going to be obvious that what you're doing is trying to garner some interest with your offering, and it's just a tougher sell. Why would you just suddenly magically post a couple of weeks before your offering and then stop posting afterwards?
Yeah. The consistent value add is what I see from operators that I believe are doing it correctly, that are dealing with 506Bs. Obviously, with the 506C, they can pretty much put anything they want, and you can tell it when you go to their website, because they're very specific on past deals. Yeah.
You do still want to be careful with 506C. 506C is not a license to do whatever you want to do. I think that's something else that people are not realizing. I think I'm starting to see more and more people do 506C. So I think this is why it's coming up a lot. But even in a 506C, I would be cautious about, giving really specific details about the returns or the IRR or anything like that, because the anti-fraud provisions still apply, which means you've got to give everybody, full disclosure of the information that you're giving. So you can't just tell somebody they're going to make 20% and then not tell them kind of what the risks are. But obviously there's no room in a post, in a Twitter post or a Facebook post or an Instagram post. There's no room for that. So unless you're prepared to just put the big fat disclaimer on your post, I would stay to a little bit more of a broader look. Hey, I've got a 100-unit apartment complex under contract. I'm looking for investors, and on a 506C, you can definitely do that. And then point them to your website or point them to a page. And then there you can get a little bit more granular, because there you've got way more room to put all the at least preliminary disclosures, because obviously the main disclosures are going to be in your PPM.
Right. Yeah. All the disclosures, any disclaimers, where they can learn more, obviously. Yeah, that's great. So for syndicators looking to accept money from foreign investors, what should they keep in mind when preparing to do it, and then during the process, let's say?
Yeah, it's a great question. A lot of people do have international investors. A couple things you want to think about. First, may or may not apply to you, but if all of your investors happen to be outside of the US, all of them, and you're not doing any marketing efforts in the US, you're not selling or marketing or have any investors in the US, 100% of everything's happening offshore, then the SEC doesn't care. Like, they don't care about international investors. They only care about US people. So there's actually an exemption called Regulation S, Reg S, that deals with scenarios where all of your investors are abroad, and you don't have to worry about 506B, 506C. Again, the SEC doesn't care. Now, if you've only got a few investors out there, or there's a mix and you're still doing a 506B, the other things you've got to think about primarily are you become kind of an IRS agent when you're dealing with international investors, because you are required by the IRS to withhold 30% of international investors' monies prior to sending them overseas. And the reason for that is quite simply, there's really no incentive for the foreign investor to file taxes in the U.S. And so if you don't withhold it, they're going to be gone. They're not going to be filing any tax returns in the U.S. So this is the way, a mechanism that the IRS has to kind of get that money. And the sponsor and the company could be responsible for that tax if they do not withhold, and then the investor does not file a U.S. tax return. So that's something you want to be really careful about. The other issue that comes up is, obviously, even though on the foreign soil, the U.S. may not care about the foreign investor, the local rules and regulations obviously apply. So if you're raising money from somebody, let's say in Canada, then you obviously want to make sure, if you're traveling to Canada and you're doing it there, that you want to make sure you're complying with Canadian securities laws. Or if you're in Brazilian, if you're in Europe, whatever, you want to make sure you're complying with those securities laws. And then I think the last thing I would mention is, just remember that not all countries recognize our entity structures. So we typically use LLCs, limited liability companies. But again, picking on Canada, Canada does not recognize the LLC. They don't know what that is. Just like there's a bunch of other entities worldwide that we have no idea what they look like. And so if you create an LLC and bring in an investor from Canada, the Canadian government looks at that as a corporation. It defaults. It doesn't recognize the LLC, so it defaults to a corporation, which results in a double taxation, as we know, for the Canadian investors. So I've had situations where Canadian investors are really upset at the end of the year because when they consult with their tax professionals in Canada, they get double taxed and their returns get withered down to almost nothing, and it's not really worth the investment anymore. And so they start complaining, and you may have to return their money. So it's just really important. And then there's ways around that. So once you recognize that, in Canada specifically, they recognize limited partnerships. So we just kind of do that as a funnel. Other countries may recognize other entities. So you just want to be cognizant of that and make sure that you're structuring your offering to make sure that that the foreign investors, their countries recognize that entity.
Yeah, it's really having a CPA that you can speak to that is well-versed in knowing tax treaties, knowing about foreign investors, and that can handle that part for you when it comes to distributions for your investors.
It's critical. If you're going to deal with, and maybe I should add that to my list, if you're going to deal with international investors or accept internet, you really want to have a really good CPA that has experience in cross-border transactions, because not only on this 30% withholding, but just all those other little things that come up, you want to make sure you're dealing with somebody who knows what they're doing.
Yeah, one last thing I've heard from CPAs as well is this is for syndicators, is that don't take any money internationally. Make sure it's in from a U.S. bank account being sent to you, because it doesn't matter who you are as a syndicator, you don't have access to 100+ anti-money laundering department at Bank of America that can do their due diligence on X person and Y entity. So
yeah, the anti-money laundering is definitely another issue there. And again, I think if you go through like you mentioned, you're spot on. If you go through all monies that come in internationally actually have to go through what's called an intermediary bank before it gets to your local bank. And that's where they're going to do their due diligence. One other thing I may want to point out, because this has happened too, is because of all these anti-money laundering rules, it's not so much that, what are the odds of you accepting money from somebody, that's laundering money, but more importantly, that money it has been frozen, meaning the money comes in, especially if it's a large amount. Like this particular gentleman that wasn't a client, but he was telling the story where he had a $5 million check come in from overseas. Well, $5 million is a big number. And so that causes a freeze at the bank level, and it has to go through all these levels of approval. Actually the government has the right to take that money. It might take 2 or 3 weeks for them to clear the money and give it back to you. Wow. In the meantime, this guy had a Monday morning close. And so he was like sweating bullets because he couldn't get access to the $5 million and he had to close and things. So one of the things you probably want to do is if you're expecting a large wire from an international, when I say a large amount, probably 500 or $1 million, then I would probably check with your local banker just to make sure, hey, what information do you need from me or from the investor so that we can make this as smooth as possible? Do you need a passport? Do you need ID? What do you need so that when this money comes, there's no surprises and I can actually use it within a reasonable amount of time?
Yeah, no, that's all great information that every syndicator and every passive investor should be aware of before they get involved with a transaction like this, especially when funds are not 100% in the United States already. So one thing I want to circle back to, and you're talking about different entity structures, and not to go into the taxes, but to go into, I saw you put up a post a few months ago about land trusts not having asset protection, where I think every investor in the United States that holds real estate uses an LLC. For the most part, right? If they're not flipping for passive investing, let's say. Right. So can you give us a little overview of land trusts, what they're really used for, and why they're not asset protection?
Land trusts, like you said, most people do use LLCs, maybe limited partnerships as well, but some, and it's primarily in Florida, to be honest with you. So Florida land trusts are big, for, I honestly don't know why. But the one thing to consider is that all trusts, including your living trusts, have no asset protection value unless they are an irrevocable trust, meaning once I set up the trust and I transfer the assets into the trust, I no longer have control or the ability to do anything with them. I can't take the money out. It's literally an irrevocable trust, which usually is used as an estate planning tool to pass on, your assets to your heirs. Or what a lot of people do in the asset protection world, especially when you get to a certain level, is you have an asset protection trust, which is, again, different from a living trust, which is different from a land trust. So unless it's an asset protection trust or an irrevocable trust, it doesn't have any asset protection value. So the land trusts are typically, they're definitely revocable. The argument for them is that they provide privacy, which they do. And so when you own real estate in the trust, it just provides a level of privacy, but you can obtain that same level of privacy through LLCs if done right. I mean, if you just create an LLC in Texas, and that's not going to do it. But if you combine the LLC with a management company that's in a state that has privacy, then there are definitely ways, I mean, we do this all the time, that we can basically make you invisible if we wanted to in terms of the public records of your ownership. The way that you get around that, which is fine. So if you have a land trust, you have to have the beneficiary of that trust be an LLC. So you end up doing it twice. So you still have the same LLC that you would have set up if you didn't have the trust, but you have the trust as well. And so anyway, so I'm not a big fan of the trust. I don't want to, there may be some other reasons to have it, but certainly not from an asset protection standpoint, because it does, just like your living trust. A lot of people say, well, I've got my house in my living trust, I'm protected. And that's not the case at all.
Yeah. Yeah, no, it is big in Florida. It's funny that you say that, because I know a lot of wholesalers that preach about using the living trust as asset protection, as they call it.
Yeah.
But
one caveat, because this may be, and I know this happens in, although I actually looked into it in Pennsylvania, but sometimes there's a tax reason to do it. Although I never got to the bottom of this, but there are some, when you transfer real estate, there's typically some states and some jurisdictions have high transfer taxes. And so sometimes having a trust may negate that transfer tax. And so again, there may be other uses for it, but it would not be an asset protection use.
Right. Okay. Yeah. Mainly privacy. That's what I've heard. So, you work with a lot of different syndicators. What are common mistakes or pitfalls that you see with syndicators and overlooked items or something of that sort?
Yeah, I think the number one mistake I see is just people not realizing that they're dealing with securities, honestly. So if they're first-time syndicators, they don't know any better. They're just like, hey, I'm just raising some money. Why is the SEC even involved? Like, I just want to get a couple of friends together and take their money and do this deal. And usually there's smaller amounts, but then this is great on bigger pockets. And then somebody be like, hey, you really should talk to a securities lawyer. And they're like, what do you mean? Why? So that's kind of on the newbie side. But then on the more seasoned side, it's just people trying to get around the securities laws by coming up with some, interesting structure. Or it's like, well, I won't bring my investors in as an LLC. It'll be a loan, or it'll be a side contract, or a profit sharing agreement, or maybe we'll do a TIC agreement. That's one of my favorites, or the joint venture. And at the end of the day, as you probably heard me beat this one like a drum, anytime the structure itself doesn't matter, right? So whether it's an LLC, a profit sharing, a TIC, a joint, it doesn't matter. It's if you're taking money from investors where the returns are generated by your efforts, it's a security. In other words, if your investors are passive and you're active, even with a joint venture, by definition, it would not be a joint venture, but profit sharing agreements, side letters, high fives, handshakes, it doesn't matter. So that's probably one of the biggest mistakes. The next one we kind of alluded to a little bit is just people posting on social media all day long with a 506B deal. I see this all the time. I've been trying to, it's kind of tough because I'm friends with most of them. So I can't just put the post up there as an example, so I'm starting to take it from other sources, but people posting on social media is a big one. And then the other one that's becoming a big one that I've also been a little bit of a broken record on is just paying people to raise money for you. People aren't aware, they're not lawyers, so that makes sense. They're not aware of all the licensing requirements that you need in order to raise money. And when you're raising money for yourself, or you're a sponsor or co-sponsor, then there's some exemptions you can rely on. But the amount of people that I see that are just purely money raisers that get compensated, a percentage of the GP, depending on how much money they raise or bring into the deal. And that's the only thing they do. That's broker-dealer activity. They're basically raising money without a license. And it's an issue for the syndicator because the syndicator doesn't disclose that, right? Why would they? They're not disclosing that they're paying an unlicensed broker to raise money for them. And then on the person side, they're obviously practicing without a license. And so, their penalty is disgorgement. They've got to return the money plus interest. But I don't care too much about them. I care more about my clients that are syndicators. And so that's what I wrestle with, is just making sure they understand that, sometimes you just need to raise that extra couple $100,000 to get it over the finish line. And it's very tempting to have somebody come in and do it in exchange for compensation, but can't do it.
Yeah. Make sure that every person that's involved in the general partnership has some sort of role in addition to bringing capital to the deal.
They've got to be, the key words there, that they've got to have substantial duties, and their primary role needs to be something other than raising money. And to me, primary just means, more than 50%. So look at all the activities you're doing. Is more time spent raising money, or is more time spent doing other things like due diligence and underwriting and investor relations and, visiting the property and, everything else that syndicators do. Talking to the lawyer, my goodness.
So one more thing too, just for the listeners, when he said TIC, it's tenants in common, which we won't get into. You can just Google that on your own, because it's a very in-depth, there's all different facets to it. But so Mauricio, when should a syndicator contact you to start the process? When do you like to hear from them?
As soon as possible. Typically, I've always recommended people call the attorney as soon as they get into LOI. Just because, again, at that point you've identified the property, and we can now have substantial conversations about the particular property. You've probably got a property package. We can start the conversation. Now that we're also doing the real estate and transactional piece, we're also now working on the purchase and sale agreement. So obviously we want to get involved at the LOI stage, because we'll probably have 3 or 4 days to get a purchase and sale agreement drafted and ready to go. So it's got to be early. I know that some people will either argue or even teach that you want to wait until you clear due diligence before contacting the attorney, because, hey, the risk is you pay the attorney a big fee and then you end up deciding you're not going to move forward on the property. My response to that is, it just puts a lot of pressure on everyone, because now you've cleared contingencies and now you've got not that much time to raise money. And it takes a while. The process does take a little bit, although we do have a pretty fast turnaround speed. But, I alleviated that a while ago by just giving just a credit. So like, hey, look, if you end up pulling out for whatever reason on due diligence, we just credit you to the next one anyway. So I try to take away that risk and really encourage people, because I really wanted, we make so many decisions on the front end of how we're going to do this offering. And so a lot of what tends to happen is, if I get a call too late in the process, we may have this discussion and be like, hey, I want to do a 506B because I want to take non-accredited investors. And it turns out they've been posting on social media for the last couple of weeks or a couple of months because they didn't know. And so we just tie our hands. That's why it's so critical to do it early, because we can make all these decisions on the front end, come up with a game plan, and then we can disseminate that information and talk to our investors in accordance with whatever rules and regulations we're going to pick, what exemption we're going to go with.
Okay, great. So after the LOI is executed, then they can reach out to you, let you know, and kind of start working with you. And it's great that you're able to do that with the credit to next deal. So I haven't heard that from other attorneys. So that's awesome.
I just try and eliminate, the risk from people. So I mean, we've been tinkering. I mean, we've been doing this for a long time. So we tend to listen to our clients, and so we tweak things to make it as easy as frictionless as possible for our clients.
So Mauricio, how can our listeners learn more about you and your firm?
Look, the best way to get a hold of me is either through the website, premierlawgroup.net. Obviously, I'm super active on Facebook, so if you want to check that out, that'd be great. I post a lot of stuff on Facebook, and then my YouTube channel. And if you want to email me directly, you can always reach me at TEAM at premierlawgroup.net. I am coming out with an ebook that's coming out. That should be coming out here in the next 2 or 3 weeks, called The 5 Things Every Syndicator Must Know to Stay Out of Jail. So if you want to copy that, you can just shoot me an email. Just put this podcast on the Ray line, and I'll send you a copy as soon as it's done. That's awesome. Yeah, it's a great name too. I saw you going back and forth and brainstorming on social about that. So that's great. Yeah. So, well, thank you very much for being on the show this afternoon. And I look forward to speaking to you in the future. Thanks, Charles. Appreciate it. Talk to you soon. Bye-bye. Take care.
Hi guys, it's Charles from the Global Investors Podcast. I hope you enjoyed the show. If you're interested in getting involved with real estate but you don't know where to begin, set up a free 30-minute strategy call with me at schedulecharles.com. That's schedulecharles.com. Thank you.
Thank you for listening to the Global Investor Podcast. If you like the show, be sure to subscribe on iTunes or Google Play to get new weekly episodes. For more resources and to receive our newsletter, please visit globalinvestorpodcast.com. And don't forget to join us next week for another episode.
Nothing in this episode should be considered specific, personal, or professional advice. Any investment opportunities mentioned on this podcast are limited to accredited investors. Any investments will only be made with proper disclosure, subscription documentation, and are subject to all applicable laws. Please consult an appropriate tax, legal, real estate, financial, or business professional for individualized advice. Opinions of guests are their own. Information is not guaranteed. All investment strategies have the potential for profit or loss. The host is operating on behalf of Harborside Partners Incorporated exclusively.